The court is now open. God save the state and the honorable court. Please be seated.
One thing I've been wondering about, and I don't know that you made this argument in your brief, is the Vice Chancellor found that Latches barred any claim that the new members were not properly admitted. Is there any disconnect in then using those same facts to imply a term of a contract?
Justice Valahora, there is a complete disconnect.
I take it part of the thing is where you said the latches comes together with this is your friends on the other side, client, assumed all along that these new members were members. They bargained for them to pay a higher entry price because the business had been successful. And that from the standpoint of implying something is if everyone assumed that these folks were members, if they didn't button up the formalities and you can't challenge it under latches anymore, there's no gap to thing. You just, and there's no, it's not as if one of these cases where everybody, there are alternative entity situations, you would agree, where somebody acquires equity without anybody knowing about it, and they might be an assignee, right?
Correct, Your Honor.
And in that situation, the formula wouldn't apply to an assignee. And if the rest of the members were then trying to force an exit sale, there might be a gap to figure out what do we do when there's this class of people who acquired equity. They're not actually a member. They're at a different tick rate because when they acquired the equity or something like that. But what you're saying is that just doesn't pertain here because whoever missed the formalities, it actually included their board representatives.
All three of them, Your Honor.
And,
all three of them.
and if latches, if they can't complain about the status of these people as members under latches, what is the gap?
Correct, Your Honor. They're members.
How did this issue get injected into the case?
Your Honor, the Vice Chancellor raised it sua sponte at summary judgment. Okay? They
So
did
neither of the parties, in fairness to your friends, their argument was about the top off, about the other things. They never actually came up with this argument in the first instance.
That's right, Your Honor. They argued for leave behind. They argued for a completely different contractual interpretation all throughout the trial. On summary judgment, when the Vice Chancellor found that the highest amount theory was the only reasonable reading of the...
Are you arguing, are you arguing that the, this implied, the idea that these folks weren't, that there was some uncertainty about whether they were members in all respects, that this was, are you arguing that it wasn't even fairly presented because your friends didn't present it in their post-trial briefs?
Yes, sir. We're arguing that nothing they're arguing here was fairly presented below.
Right, so that you didn't have a chance in your answering post-trial brief to even address these things, and then it manifested itself in the court's post-trial opinion as the primary reason why you lose, right?
That is exactly right. The Vice Chancellor found on the basis of an argument that the minority members never made post-trial. They abandoned it. They made it in a sentence in their pretrial brief, didn't make it in their post-trial brief.
A sentence?
One sentence.
In the pretrial brief?
One sentence.
None of the requirements in the LLC agreement were complied with. And in fact, as the court below
Wait a minute,
found,
but this is big boy law. I mean,
Yes, Your Honor.
we're not talking about people who, are doing consumer transactions here.
but, Your Honor,
Didn't you also get a check for
20 minutes.
a fair amount of money?
yes.
Like how much?
I don't know what our proportional share was, but it was millions of dollars. Your Honor.
Was it over 10, 11
It
million?
might have been 10 or 11, yes.
And the other investor got a similar check?
Yes, Your Honor.
And you got that in part because you bargained to make sure that their entry fee reflected the success of the business in the interim from when you invested to when they got to invest?
Yes, Your Honor.
Right, so you focused on that, right?
Well, what we focused on, Your Honor, which was, let's go back to the trial. that
May I ask you a
even the
question?
Resolutions.
Let me ask you a question.
Yes, Your Honor.
You've now spent more time on this argument than you spent by far in the entirety of your pre- and post-trial briefs, correct?
No, Your Honor, I don't
Well,
believe
then
that.
explain that.
Okay, so on the
And,
question.
and in this, and explaining this, realize that several of us here all of us practiced in courts, and a couple of us were trial judges.
Yes.
And we take very seriously when excellent firms like you and the people you're affiliated with in Delaware write sections of briefs and had things with arguments. So your friend on the other side said that you had one sentence in your pretrial brief. I don't think you dispute the fact you had nothing in your post-trial briefs.
I do dispute that fact, Your Honor. and I'll
Okay,
cite
you
the
had
court
an
to the record.
argument section in your post-trial brief on this theory?
On the theory that...
The theory you won on.
Right, yes, Your Honor. So at the record at 6:35...
Did you believe, you knew it was family, like this is the season, all the stores tell you it's Family and Friends Day.
I'm sorry.
Family and Friends Day, like, if you go in to buy a Ford, you get the same discount of a Ford dealership, you go into Macy's. No, seriously, I just want to know how many years ago your client supposedly fell off the turnip truck, that they assumed that these family and friends of Mr. Koch were not in fact family and friends, and that if there were entities used, they were not entities controlled by either Mr. Koch or affiliates of Mr. Koch.
Because it was never disclosed, Your Honor.
And you
in
didn't
fact-
care, right?
Well, we
And you
cared.
cared about getting the entry price,
We-
and you made sure you got the entry price. And you also, the record, and this is where the Vice Chancellor's in tension with himself, he says you all didn't care because you actually thought the business was thriving so much that the hurdle rates were never going to be a big deal.
The company did not need the capital.
Well, but no,
This was not-
he may be right about it. When you look back from 5 years, when you wish to force an exit sale, and when it turns out the business did not do as well as you had thought at the time, and when you're kicking yourself because you wanted the extra money and you got your 11 million bucks, but now you think it's something much more than 11 million bucks. When you look back, I mean, there's lots of times in life where, you wish you had shot the ball instead of passed to a teammate or vice versa. Doesn't mean you weren't thinking at the time. It just means you didn't think well. And that doesn't mean that you have a gap because you get to do a do-over, right? And how can, I mean, it's essentially, how can, if you can't challenge their status as members, and you can't deny to them the contractual rights they have under these exit sale provisions, how can the court then imply a gap and then basically ignore its own laches ruling and give your clients relief? I don't get it.
The agreement makes clear that the rights
Where
of
did
new
you,
members...
where did your client ever express, either of the two people in league, ever express the least bit of curiosity about, oh, these folks must have very different rights? It just must be, someday we'll get to that, and we'll figure out what the family and friends' rights are. You never did that, right?
Because it was a non-issue.
Until it mattered to
No,
you.
and remember, Mr. Koch is a fiduciary. He has a duty to make disclosure here. None of that was disclosed.
Well, you
It was
also,
hidden
wait a
from
minute, your
us.
clients are actually on the board too, and also have a fiduciary duty to the people whose rights they're now seeking to deny after
Without
5 years
question.
of acquiescence in acknowledging that they had rights and after taking proceeds of their purchase, right? Does this add up to a gap? Because if you're
Well-
right about a top-off, you win. If they're right about the plain language of the agreement to live, but in neither case is there a gap unless you as fiduciaries are seeking to deny to members whose money you took the rights they have as a member, because when you never actually thought they had different rights.
Well, because, Your Honor, the gap is...
So are you guys giving the money back?
Let me ask you a question
Yes, Your
on
Honor.
that, because this whole small holders' rights gap is not point one in your argument on your answering brief. It's this new plain language
May I address?
argument. And how do you respond to your friend's assertion that, number one, this wasn't raised, fairly presented below, and number two, not only that, it's contradictory to your own client's testimony who said, quote, "We did not have a top-off payment right."
Let me address both.
And three, that it conflicts with your implied covenant top-off gap theory.
9B.
I've
Those are the
never
very
understood,
provisions.
can I just ask a question about the substance of Justice Alhero, just one about your argument? I get how everybody would think that, or they'd want to top off. I never have understood how it fits within the contractual language, because I don't understand why anybody has an obligation to accept it. And I don't understand what the top-off payment, what transaction it's part of. Because if it's part of the exit sale, then it's supposed to come from the buyer and be part of the consideration. If it's to use a Louisiana phrase, if it's a lagniappe added from another member in order to force the exit sale, wherein does the contract provide how that's supposed to happen? Why, and what you're trying to argue is that somehow you have everybody has the duty to kind of comply with and aid the effectuation of a complying exit sale, right?
That is one of our arguments, yes. Your Honor.
Yes, but then the exit sale consideration doesn't include the top-off, but you have a duty to accept the top-off to facilitate an exit sale. And it also, you know, if people wanted to do this, wouldn't they say, do the equal consideration thing and say, provided, however, that if a member who wishes to force an exit sale wishes to take some of the consideration that they receive to satisfy someone else's hurdle rate, then they're able to do that and force an exit sale. That would seem like something you could scriven.
Yes.
Why do
yeah.
friends and family have to accept diverted consideration?
Three answers, Your Honor. First of all, it's resulting proceeds. Second of all, it says.
But it's not the way the offer is structured. Those proceeds went to your clients.
And what it does is it
By the way, when this
satisfies-
offer was put on the table, it didn't have a top-off, it didn't have all this intricacy in it, right?
No, the offer from the buyer was an
Right.
offer.
Can I ask you a question, just so,
Yes, Your
I mean, sometimes it nags at human beings when they're doing something and there's a curiosity that emerges. Were your clients, partners in the buyer? Which is, were they intending to have an ongoing equity interest in the buyer?
That was
in
under dis-
in the company once that was acquired?
That was under discussion.
And so, under discussion, because that just makes entirely irrelevant all this really intricate stuff that you put in everybody's put in everybody's head at holiday time, right? That's clearly not okay in terms of that without offering the same terms to Mr. Koch and the other members.
And I don't know that the record addresses that issue. I don't think
No,
that
no,
issue.
I mean,
I don't,
what I
Your
mean
Honor, that
is
was
that-
never
no,
raised.
I mean, I understand that. And
was
I'm
never
just
raised.
asking, Matt, you've been candid. This was going to be probably like a private equity play, but the other members were not going to receive an opportunity to roll into that structure. Your client and its colleague fund would, right?
I've explained. It's completely consistent. The plain meaning argument that we've advanced here is consistent with the argument we've made below. The implied covenant argument and the implied covenant ruling that His Honor below, Vice Chancellor found, is also consistent. Because
Let me
what it-
ask you one more question before
Yes,
your
please.
time runs out on that. Would you agree that if we were to view the time of contracting as 2007 instead of 2011, you have a very difficult time on the implied covenant, given the testimony on the other side that a top-off would have been a deal killer?
Well, if I can answer the question by saying, the court below expressly found that the time of contracting here was 2011. That's
Well,
verbatim.
if we find that to be error,
Well,
is my question.
The parties left open, what the court below found, referred to as an intentional gap, left open for future
But
determination.
isn't that sort of oxymoronic to say there's an intentional gap if the
It
implied
was,
covenant?
it was the court below's way. There was to be an amendment to the LLC agreement. And so when we look at, I'm sorry.
I believe Justice Valor is satisfied with your
Yeah, thank
answer.
you.
Thank
and-
you.
With respect to your argument of waiver
Yes, Ron.
on the issue of whether the failure to set terms and conditions in 2011
Yes, Ron.
created a gap,
Yes.
that argument's been waived. But this sort of the factual predicate, as I understand it, of that argument was made below. It was just done in the context of whether the smallholders' admission was done properly.
That's exactly right, Your Honor.
So what, my question is, what is it that you didn't get to present or argue in the court below by virtue of the change in the,
Your Honor,
Senator.
Rule 8 is a function on fair presentation on their part. They didn't make that argument. We didn't get to counter that legal argument because they never dealt with and present facts concerning that legal argument because they never made the argument.
What you're saying is, that is not an argument that relates to whether when the friends and family came in, they had the full rights as other members. It's simply an argument about the facilitation that a member has to do if it's offered a top-up.
That's exactly right. And to Your Honor's point, to the Chief Justice's point, the record is undisputed. The evidence is undisputed that the Crestview parties were going to roll into the ArcLight transaction. That's the opinion at 90.
Why didn't you just simply argue, like, hey, that's not the same terms, and duh, that doesn't qualify?
We made that argument below, Your Honor.
It just wasn't considered?
Correct. It was not addressed. I think the Vice Chancellor, as I recall it, rejected that argument. But we certainly made the argument that the ArcLight offer failed the all securities requirement, which requires that a transaction be on all but not less than all, and the like. So
Thank you, Counsel. Happy holidays to everyone.
Thank you.
Please rise. Hear ye, hear ye, hear ye. All manner of persons having anything before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of the court. The court is now adjourned.